But if successful, we should be set a precedent there, and perhaps a global precedent as well, as to how to challenge a government that definitely seems to be overreaching as far as regulations and limiting regulations goes.
What's happening with South Africa's ongoing COVID-19 regulations? There is much confusion about the draft protocols as well as the amendments to the National Health Act. I posed this question to Rob Hutchinson, the founder and chairman of Dear South Africa, in a recent episode of my podcast, Solutions with David Ansara. What follows is a short extract from our longer conversation. If you would like to watch the full discussion with Rob Hutchinson, that's linked in the description below. Enjoy.
I think COVID provided fantastic opportunities for all civil society organizations, in that we all suddenly became extremely aware of governmental processes as public or as citizens. Before, people weren't quite involved in the process. They didn't quite understand how laws and regulations are promulgated. But during COVID, everyone was granted an opportunity to view the insights of policy formation. And we seized that opportunity as a public participation organization when the minister put out new regulations under the Disaster Management Act. We had to question some of them: open-toed shoot, warm dinners, ban on e-commerce, certain restrictions on exercise windows, and many more, closing of schools, and so on. So we ran several campaigns throughout COVID, and we're still, some of which are still running, all in response to regulations and irregularities amongst those. We were quite successful in influencing and the withdrawal of regulations. One was e-commerce. We could not understand why that was banned. So we challenged the minister at the time, and that was withdrawn. It's great. We sometimes we don't get the credit or even seek to get credit on what we do. We just want to see it get done. So a lot of other parties jumped on the bandwagon, including political parties, and saying, "Oh, we did this, and we don't mind. We don't mind. We know." We wrote letters to the minister, showed the public participation, and gave a set a deadline to respond or withdraw by a certain date, which is exactly what the minister did on 3 separate occasions. And because of that, we decided to focus heavily on COVID regulations, the Health Act, Disaster Management Act, and everything else related to unwarranted lockdowns, but with an open eye, rather than oppose everything that comes out. We wanted to hear the public's view on these matters, and then we acted legally through the courts, based on the feedback from the public. So we didn't act and represent ourselves. We represented all participants in South Africa, South African citizens in general. And yeah, it's been an absolutely great time. Well, I wouldn't say great time during COVID, but it's been an interesting time, without a doubt. We've definitely grown as an organization. The public, and one of our main functions as an organization is to educate the public to the importance of getting involved in democracy at a day-to-day level, not just at elections. And COVID certainly did provide that opportunity and that awakening. So yeah, it's been a good time during COVID for us. I go back to saying it's a good time, but it has worked well. The fight is still on with the shift of the regulations once housed under the Temporary Disaster Management Act. They are now being moved to be permanent under the National Health Act. And that is a major concern for us, because even the regulations that were once set aside, like isolation measures and forced quarantine and so on, have crept back. They're back into the proposed regulations for the Health Act, and if they are accepted, they will become permanent under the Health Act, because it is, of course, a permanent piece of legislation. Whereas the Disaster Management Act, although set aside now for COVID purposes, the regulations seem to be still in place. And that's also created confusion as to what's actually going on in Parliament. So when the Disaster Management Act was withdrawn by the President, they had in place what they call temporary regulations or interim regulations, and those mask wearing and social distancing and venue capacities were still in place. Those temporary regulations were only supposed to be there for, I think they actually called them limited regulations, were only supposed to be there for 30 days in a cool down period. However, those regulations in particular have now been adopted to be permanent under the Health Act. And that was without any public consultation or review process or comments from the public. In the meantime, they've put a set of draft regulations together, which were what were once housed under the Disaster Management Act. And the intention with those is to move them to be permanent under the Health Act. And those are the ones that are currently open for public comment. Our main thought is that they will slowly move certain regulations one at a time or a handful at a time to be permanent, as they did with those limited regulations, and which makes the whole public participation process on those draft regulations kind of pointless. But nonetheless, that's why we have taken the minister to court on the regulations, on the limited regulations, and the draft regulations, and we'll be in court on the 26th to the 28th of July, challenging all of that. If successful, I'm always hesitant to say when successful, but if successful, we should be set a precedent there, and perhaps a global precedent as well, as to how to challenge a government that definitely seems to be overreaching as far as regulations and limiting regulations goes.
Yeah, and I think it's very important to check that excessive state power, Rob. So you mentioned litigation. I mean, how does litigation form part of your strategy? So it's not just that you're making submissions to Parliament or whichever government department, you're actively taking on bad policies as well in the courts. Yes. How successful have you been in the legal arena, and what is your approach?
Our approach is pretty simple. We act in favor of the participants, and if the public participation process has been flouted or ignored, then we have an obligation to challenge it in its entirety. And the objective there is to either restart the public participation process or have it set aside and to declare it as unconstitutional. And we've been very successful in our court cases so far. The first lot was getting the certain regulations right in the beginning. I think it was in 2020, having certain regulations withdrawn. That worked out very well. And we've challenged many other pieces of legislation that we seem, that the public informs us or participants inform us to be incorrect. So if government goes ahead and implements something where the public have wholly objected to it, then we will act in favor of the participants and have that addressed in court. And most of the time, government retracts. They announce that they're going to challenge our application, but then they retract at a later stage once presented with the evidence of public participation. It's an incredibly powerful motivator, and obviously government is afraid of backlash from the public or from us or from other organizations that we collaborate with.
Thanks for watching. If you enjoyed this discussion, you might want to check out the full interview with Rob Hutchinson That's linked over here. You can also check out my other channel that's linked over here. My name is David Ansara. This is the CRA. Until next time, take care.